Beth Nicole Martinez. I believe there is a motion to revoke.
There is.
There is. All right, could I have a file stamp, please? Court is calling 2021 CR 8476 State versus Beth Nicole Martinez. Could I have parties announced?
Ashley Jones for the state.
Robert Porter for Ms. Martinez.
Are you Ms. Martinez?
Yes, ma'am.
All right, did you review, and counsel, you have 10 days to prepare. Are you ready to proceed?
We are.
All right. And Ms. Martinez, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beth Nicole Martinez who's placed on deferred adjudication in 2021 CR 8476 for the offense of aggravated assault with a deadly weapon on October 12, 2021 for a period of 4 years? Is that you?
Yes.
All right, state.
Yes. State's going to proceed on violation of condition number 2 on or about the 7th day of October 2024 in Bexar County, Texas. The defendant, Beth Nicole Martinez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true? State.
The state will waive the remaining violations.
No objection.
All right, did you understand by pleading true to violation condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Refusing a drug test and probation isn't just a slip up. It's basically a flashing neon sign saying, I don't care about the rules. Question for you. Do you think judges should treat a missed test the same as—
Yes.
Knowing that, will you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there proposed agreement?
Actually, Your Honor, the agreement was for her to plead true to violation of condition number 2. I do believe defense and I both have different recommendations. The state's recommendation is that she receive some sort of inpatient treatment given the positive UA and the failures to submit, but I do not see any mental health directives. I mean, the only thing we have is going back as far as 2021. I don't have any current on that to show that there's DRF.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 UA was either September or October. The October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite finish complete it up. Now we're going to have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there. And the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing, it's not about whether or not you can do a fundraiser. It's about, I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my...
This is the moment that changes everything. By pleading true, Beth skips the fight and hands control to the judge. But here's the gamble. Sometimes admitting fault earns leniency. Other times it opens the door to the maximum sentence.
UAs, I may fall out of this program. That's what it's about. It's not, I'm struggling. I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just going to stop submitting you to drug testing. I'm not going to do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did good the whole time I was on it.
So let me ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager and it wasn't working. So your response to that was to do what with your probation?
I was just overwhelmed. I had too much stuff going on. I was losing
All right,
my
so
father's house.
your decision with probation was what? With felony drug court? See, I'm trying to get you to point, because see,
Well, I know where I messed up. I'm not saying I didn't.
yeah, but so that's the thing. You didn't learn anything from felony drug court, because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping. Everything's going well. I get a call at 3 a.m. It's a Monday.
This is the collision of law and life. Grief, financial stress, and probation don't mix well, but the justice system rarely hits pause for personal tragedy. Should courts weigh personal hardships more heavily?
I get a call at 3 a.m. And you know what that call is? It's from my younger brother. And guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why didn't you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left message to everybody, hey, my grandmother just died. I'm going to have to go home. So I tell you that to say everybody has problems in this world. But your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not going to do that, then you got to accept that. You're on paper. That's what we called it when I was a defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is for 2021. I do not see, I don't have any information of it.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm going to give you a choice.
Wow. The judge just shifted gears from legal authority to personal vulnerability, sharing her own loss to hammer home a lesson. It's rare to see this kind of humanity in court, and it makes her message about responsibility.
Deny the motion. You're not getting out of jail today. You're going to do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long. I think that's the right choice.
Will I get my back time if I sign up?
Sure. All right. We're back on the record. Yes. So what do you want to do?
Do the TAP evaluation.
All right. So the court will deny the motion, alter and amend conditions to include in custody. There's to be a TAP evaluation, follow all recommendations, and there's also to be an updated MIC evaluation in custody. And is there anything else that's being requested, State?
Oh, yeah.
And is there anything else you need from the court, Miss? Is there anything else you need from the court?
Amen.
All right. And there's to be no residents with minors. All right. Thank you.
Thank you, Judge.
You're welcome.
I'll make him balance case, please.
Yes. Court is calling 2024 CR 011095 State versus Luis Okura. Can I have parties announced for the record?
Andrew Harris, Edelman.
Hector Algarve Jr. for the defense.
And are you Mr. Okura?
Yes, Your Honor.
Just 1 second. Counsel, have you received all discovery and did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is.
Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Classic courtroom strategy. The judge offers two choices, but notice how the framing nudges Beth toward the evaluation route. It's less about freedom of choice and more about guiding her into the outcome.
Reading of the indictment.
We do waive.
Are you proceeding on the indictment as presented?
No, Your Honor.
Any objection?
No objection from the defense.
Mr. Court, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand, in count one, you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel that he is and was.
Mr. Okora, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at a cap of 6 years in the...
And here's a crucial reminder. Sometimes the smartest move in court is silence. Oversharing, even when you're emotional, can undermine your defense. Do you think defendants should ever speak for themselves or always let their lawyers do the talking?
prison. There's a $2,000 fine. State is silent on your application. They're taking consideration NIGHT number 760070. There's to be restitution and no contact to the complainants. Did you understand that to be the plea?
Yes, Your Honor.
And did you understand if the court were to determine that there is a weapon used, the court would make an affirmative finding of a deadly weapon? All right, defense, is that the plea?
It is.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
There has not.
Then to count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections from the defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to set this for a PSI, it'll be 8 weeks. But if you would like, what we can do is I can reset it for a sentencing, and you can bring in whatever witnesses you would like to bring in, and I'll ask the state for his criminal history. So which would you prefer?
We're going to bring in several witnesses, Judge.
All right, so are you waiving the PSI then?
Sure.
All right. So what date would be good for you, counsel?
I would like to look towards April, Judge, just to make sure that we can coordinate with the individuals. At this point, I have the 22nd or the 23rd available.
I can do it the first week in April.
I am in Del Rio and then Eagle Pass 3 days of the week, so I'll be out from Monday through Thursday.
Mhm.
The following week, the earliest I would be able to do is the 10th.
All right. Ms. Ferguson, if you'll put this for April 10th for sentencing, and the PSI is waived. And we can go off the record, what ended up happening, the state is silent on your application. The only thing I'm gonna need from them is your criminal history, if you have any. And then I will hear whatever witnesses or evidence your attorney wants to present to the court. And then I'll make my decision on your application based upon any evidence that I hear or receive, okay? Do you have any questions about anything? All right, once you sign the reset form, you'll be excused. Just have a seat and your attorney will bring it to you. You're welcome.
Thank you, Judge.
You're welcome.
Yes, we do.
Hello, Ms. Martinez. All right, so what is the update on the evaluation?
2 weeks ago, she was found incompetent. We should be going back again to that court. She wanted to order some other testing because it was believed, and after she's done with her treatment, that she will become competent. That'll take a while. So that's where we're at right now. And I think we got another hearing this week to discuss the other testing that the state was smart to give her some more evaluations to try to help her understand her problems better, as well as the people that are treating her.
All right, Norma, set this for the 4th week in May, please. Isn't that a holiday?
Why not?
All right, May 27th. All right, we're going to bring you back to this court on May 27th. We can't go forward on anything until a doctor states that you are currently competent, okay? Do you have any questions?
For Cordova,
I'm sorry, you have what?
for Cordova, because something that I was trespassing and that I have spit on his mouth, which is I didn't. I had a.
All right, so
wash
let
my
me
mouth.
explain.
Already 3 times a
So it's probably best for you not to speak about your case. All right, so, and I just say that for your protection, because your attorney may have different defenses that he wants to put forth in the court. But what I can tell you is, until I get something from the magistrate's court saying that you're competent, I can't move forward or do anything with this case. You understand?
Okay.
All right. All right, thank you so much.
Thank you, Your Honor.
You're welcome.
And I'll be excused.
Yes, you may be excused.
Thank you, Your Honor.
Mr. Sullivan, you still have another client.
Oh, I do?
Yes, he's gonna go and get him.